everybody, and welcome. My name is Laura Ferguson. I'm the Director of the Programme on Global Health and Human Rights, and also part of the steering committee of the Law and Global Health Collaboration. And I'm really pleased to welcome you all to another talk within the Law and Global Health Collaboration series. And we're going to be continuing our focus on sexual and reproductive health and rights, which has been what we've talked about all of the year. It gives me huge pleasure to introduce Justice Dingake. He's been a judge for over a decade. He's currently a justice on the National and Supreme Court of Papua New Guinea. Originally from Botswana, he also served on the High Court there. And he's known throughout sub-Saharan Africa for his work on HIV and the law, on gender justice, and on issues around sexual and reproductive health and rights. And he's done a lot of very progressive work throughout the region, seeing as one of his key responsibilities as a judge to raise human rights standards, which is something we love. So I'm very pleased to welcome him here to USC today to talk about sexual and reproductive health and rights in Southern Africa.
Thanks so much, Laura, for the kind introduction. It is indeed a great honor and privilege for me to be here to share with you some thoughts on sexual reproductive health in Southern Africa, focusing on Botswana, Swaziland, and South Africa. I think we first met with Laura in my own home country, in Gaborone in 2015. Or 2016 or thereabouts, and I'm happy to notice that we have since made progress in strengthening professional relationship, and that explains why I had to take a detour from Carbondale, where I was based for the last 10 days, to come via Los Angeles to deliver particularly this talk. I think it is always wise before one engages on issues of this nature to touch base with the conceptual and theoretical framework just sufficiently to enable us to proceed on the same page in terms of what we are talking about. I am certain that there may well be professors like Laura in this group who may be bored to death by elementary definition of concepts, but it does help to refresh our own memories and to be able to define the universe of discourse in order to be on the same plate. So I'll do that briefly, and then I'll go into some details and comparing Botswana, Swaziland, and Lesotho. I am a native of Botswana. As Laura pointed out, I'm currently serving in the Supreme Court of Papua New Guinea in the Pacific. When we do talk about sexual reproductive health, we should all note that we are talking about a state of physical, emotional, mental, and social well-being, and that this does not necessarily relate to absence of disease or infirmity as such. So sexual health requires a positive and respectful approach to a person's sexuality and sexual relationships. To be sexually healthy, people need to be able to have pleasurable and safe sexual experiences, free of coercion, free of stigma, free of violence. They need to have access to sexual health information services, and for people to have and keep their sexual health, their sexual rights must be respected, protected, and fulfilled. I posit that in order to do all those things, we all need to have our hands on deck. In order to protect, fulfill the sexual reproductive health rights, we need everybody's assistance, more particularly the assistance of government, and especially the judiciary that is entitled with ensuring that the rights that are granted by our constitutions, that in effect are simply promissory notes, are in actual fact given effect to. Reproductive health requires that a person is able to reproduce and has the freedom to decide if and when and how often to do so. This implies that all people have the right to be informed about reproduction. They have the right to have access to contraception that is safe, effective, affordable, and acceptable. Now, that is insofar as the conceptual framework is concerned. When we talk about sexuality, sexual health cannot be defined, understood, or made operational without a broad consideration of sexuality, which underlines important behaviors and outcomes related to sexual health. Sexuality is influenced by the interaction of biological, psychological, social, economic, political, cultural, historical, religious, and spiritual considerations. It's a complex phenomenon. I wish now, with that conceptual framework, an overview that is very brief, just to give you a flavor of the state of play in Southern Africa, and say that in Southern Africa, violations of sexual reproductive health is quite pervasive. And this is revealed by the statistics that show very high rates of rape, very high rates of sexually transmitted infections, very high rates of HIV, and very high rates of teenage pregnancies, and very high rates of backroom abortions. This also explains why Southern Africa, which is the epicenter of HIV, the rate of new infections among women and girls in the region is very high compared to other regions. So we do have not only Southern Africa an epicenter of HIV, it is also an epicenter where there is an epidemic of bed laws. By that I mean, as it will be seen when I give further elaboration on this point, that the state of the legal regime that governs matters of sexuality is either underdeveloped or absent, or is not enabling enough. Sexual activity defines the very essence of human existence. It is supposed to bring joy and intimacy. On the contrary, in most parts of the world, Southern Africa not being an exception, there is a lot of sexual abuse that is too common. Forms of sexual behavior have also been persecuted and discriminated against. People have been persecuted in law because of their sex, because of their sexual orientation, and because of their sexual preferences. Even today, sex brings persecution and death. The reality, though, that we must acknowledge, and not only in Southern Africa, across the globe, is that sexual relationships are underpinned by inequality and also underpinned by power imbalance. It is very difficult for women in the part of the world where I come from and the adolescent girl to negotiate safer sex on account of a number of structural difficulties. In consequence of all this, women, more particularly compared to men and adolescent girls, are vulnerable to HIV. In most jurisdictions in Southern Africa, women are forced to get pregnant or to carry pregnancy to term because of hostile or because of anti-abortion laws that are in place. Violation of sexual and reproductive health rights is relatedly directed to patriarchy. Southern Africa is usually the site where patriarchy appears to be even more vicious. We have phenomena like polygamy, where a man is allowed to marry as many wives as possible. Often underaged children are also maybe married to elder men. So patriarchy is a real problem at the center of the realization of sexual reproductive health rights. It is manifested in all layers of society. You look at the legislature, you'll find that it is male-dominated. You look at the judiciary, you'll find that it is male-dominated. These institutions, dominated by men, have the power by law to try to control and influence women's control over their bodies. And although today there is a breakthrough in terms of realization of sexual reproductive health in international legal instruments, and the tragedy, though, is that most constitutions of the world still do not make reference to sexual reproductive health. In other words, there is inadequate protection in law, which is the starting place of sexual reproductive health rights. Some study has shown that out of 193 or 195 constitutions in the world, only 27 countries make reference to sexual reproductive health. That is the reality of the situation. In reality, in Southern Africa, the stereotypes against women is pervasive. Women are generally regarded as minors. They are regarded as emotionally volatile, not rational to be entrusted with taking their own decisions, let alone the adolescent girl. This stereotype is often embodied in laws and is often reflected in the judgments that the courts give. Adolescent girls, on the basis of age, are often considered immature to take decisions regarding their sexuality that require parental consent. Often, the blanket denial disregards the evolving capacity of adolescents to understand or make decisions independently and confidentially. And where parental consent is required, that may prove to be a handicap to adolescents, girls in particular, to access the required information that they need. Experience teaches, and at least my experience at the bench teaches, that at 16 years, girls are fully able to make sensible decisions about their sexuality and reproduction. In Southern Africa, often law and politics collide to deny sexual reproductive health rights, as I shall show in due course by reference to some of the cases. The effect of sexual reproductive rights in the society is mainly borne by women. That is why I keep on emphasizing, especially women, especially the adolescent girl, that by not taking away the importance of men as part of the reproductive ecosystem. The sexual reproductive health right is a health and human rights issue which has become urgent and needs to be addressed holistically, as it does not only entail health and sexual reproductive rights. This is the overview of the state of sexual reproductive health rights in Southern Africa broadly. I now deal specifically with the countries that I am going to discuss in some detail. I start with my own country and just do briefly the constitutional and legal framework so that you can appreciate the access to these rights, whether the rights exist, and the efforts of the courts. Botswana obtained independence in 1966 from the United Kingdom. It's a former colony of the United Kingdom. The Botswana Constitution is an old one. It was crafted in 1966. It follows the model of the European Convention of Human Rights of 1952 and 1953. It entrenches only civil and political rights and does not make reference or entrench socio-economic and cultural rights. There is no reference nor a whisper about sexual reproductive health rights in the Botswana Constitution. It further does not include, as I said, sexual reproductive health rights. However, despite that, the public has access to free health services in public hospitals. Although Botswana has a pluralist healthcare, public and private health institutions provide essential health care. Provisions of sexual and reproductive health rights are also honored occasionally, but the rights of the adolescent girl are usually honored more in breach. The High Court and the Court of Appeal has made certain pronouncements that in the course of my discussion, I will discuss in some detail that protect and try to fulfill these rights. The Ministry of Health and Wellness is also actively involved in creating awareness about sexual and reproductive health rights services. It is worthy to state that in providing such services, there are many challenges that are encountered internally. And some of these challenges relate to the conservative attitude of the people of Botswana generally, that still consider that a child, more particularly a girl child, ought not to be heard, but only to be seen. That is a saying, that they ought not to be heard, but only to be seen. Women, until very recently, were regarded as minors that require the support of the husbands, even to execute a valid contract of a loan. Even professional women, until very recently, maybe until 15 years ago, women were still regarded as minors. Polygamy is still rampant in some other places in Botswana, exposing women in particular to infection such as HIV infection, STI, and so forth, because of the patriarchal system that privileges men. Abortion in Botswana is restricted to only 3 exceptions, only 3. 1, when the life of a mother is in danger. 2, when the life of the fetus is in danger. And 3, when the pregnancy is a result of rape or incest. Apart from that, there are no provisions to grant abortion for any other reasons, thereby compelling pregnancy in many cases. And since abortion in Botswana is restricted, there is a lot of backyard or backroom abortions. And most of our people cross over to South Africa, where there are liberal laws on abortion, as I'll discuss when I deal with South Africa, to carry out abortions in those countries, in that country. And we also have issues around lack of provision of emergency contraceptive pills. The use of emergency contraception pills in Botswana is strictly limited. One cannot access the morning after pill over the counter. It is only given by way of prescription by a certified medical doctor. It is argued that while the morning pill cannot be used as a daily contraceptive, its accessibility for those who may need it should not be underplayed. The situation of availability of emergency contraception needs to be addressed if women and girls in particular are to enjoy their sexual reproductive health rights. When you get to hospitals and clinics, one of the major constraints is the attitude of healthcare providers themselves, who actually, when young girls come to seek contraceptives, they're actually scolded or stigmatized, or even it is implied even by health care providers that they're being promiscuous. The result of all this is to turn them away from accessing the services they so much require. There is still a lot of stigma and discrimination around HIV. There is still a lot of gender-based violence in Botswana. All of these factors exacerbate the issue of HIV and the violation of sexual reproductive health. The courts have done their best to try to effect these rights, even in the absence of a legal framework that entrenches the right to health, even in the absence of a legal framework that recognizes sexual and reproductive health. I'll discuss 2 important cases in the context of Botswana. There is the case of Tuto Mohe versus the Attorney General. This is a case that was brought by an association of gays, lesbians, and bisexuals of Botswana. In Botswana, homosexuality is a criminal offense. And because it is a criminal offense, when this body tried to register an association, as required by law, at the Ministry of Home Affairs, they were told they can't register an association whose effect is to promote homosexuality or LGBTI rights broadly, because the government reasoned that it will amount to aiding and abetting the commission of a crime. So they were refused the right to register it. So they challenged the decision of the ministry to refuse to register them in the High Court. And when the matter came before the High Court said, in terms of the Constitution, more particularly the freedom of association, they have the right to form an association that can campaign for the right to health to be entrenched in the law, and also campaign broadly for the LGBTI rights. The court said there is no crime in doing so. So they were allowed to form such an association. It was a victory having regard to the previous case law that made it clear that homosexuality is a crime and that it is not unconstitutional. The second case relates to the case which I did, is the case of Gift Moale versus the Attorney General. In Botswana, we have a problem of illegal immigrants coming mainly from Zimbabwe. I understand you have yourself issues with illegal immigrants coming from somewhere. And you want to build a wall. We have not talked about a wall. So Gift Moale crossed into Botswana illegally, committed an offense, was tried, convicted, and sentenced to prison. While he was in prison, he discovered that he was HIV positive. And his CD4 count fell within the threshold that allowed government to assist with ARVs. The policy of the Botswana government was to give ARVs to its own citizens, not to everyone. That was the government policy. So when he called upon the prison authorities to provide him with ARVs, the government refused on the basis that he was a foreigner. So he brought the case before the High Court, arguing that he was being discriminated against and literally sentenced to die by the denial of ARVs simply because he's a foreigner, and that violated the equality provision of the Constitution of Botswana that guarantees equal protection of the law. The High Court found that his complaint was merited. That what is critical is that Section 3 of the Constitution of Botswana says no person shall be treated differentially on account of a number, and then it mentions the grounds. The government must have read no person as only referring that they can only provide for citizens. But the Constitution said every person has the right. It doesn't say every citizen. I don't know whether that makes sense. The Constitution says every person shall be entitled to equal protection of the law. It doesn't say every citizen. So in order to succeed in court, they had to show that Gift Moale was not a person. They could easily show that he was not a citizen. But to show that he was not a person would be a tall order. As a result, the court lost in that case. And the court ordered that the government shall provide him with ARVs. The government appealed and it lost the appeal. The result of that is that foreign prisoners currently who are imprisoned in Botswana are entitled to ARVs by virtue of that decision of the court. So there is a lesson there to say that it is well and good to provide for these rights in constitutions, but you need a judiciary to give effect to them when they are violated. And the lesson there to you is that judges matter under a rule of law dispensation. Yes, they matter. They can determine the direction of the country. They can determine access to health. They can even determine, as you know, who your president should be. I'm referring to the case of Al Gore versus Bush. I do not know whether it is you who elected or the Supreme Court. But that is to highlight to you that judges matter. Judges matter. The rule of law matters, and judges matter. Rights are important, but without the cost to breathe life into them, they are simply sterile promissory notes, nothing more. In Swaziland, the right to sexual and reproductive rights is not recognized in the constitution. And in Swaziland, the national policy also does not recognize sexual reproductive health rights. On average, it is difficult to access health institutions within a reasonable time, as well as to procure services that one is seeking in Swaziland. Swaziland is a conservative traditional society. There are serious limitations on rights. The courts do their best, but the attitude of society, ultra-conservative in nature, make it difficult for these rights to be permitted. As you know, Swaziland is one of the countries where polygamy is rife, where the king every year is allowed to choose who of the young girls who are paraded before him in the hundreds is going to be his next wife. And that parade takes place every year. And every year he chooses a wife. In Swaziland, there are a number of harmful cultural practices, including abducting young girls to marry them to older men, including practices such as virginity testing. All of them dangerous and harmful practices that are very rife in Swaziland. The rise of the LGBTI in Swaziland is almost non-existent. The stigma associated with HIV is very high. And HIV in Swaziland is among the highest in the continent. There are cases of early marriages in Swaziland, and access to condoms in public hospitals is limited. Although the government has tried to promote condoms, but it's very limited. South Africa has a comprehensive laws and policies that protect and promote sexual and reproductive health rights. As you may know, South Africa has one of the most liberal and progressive constitutions in the world. Not only does it guarantee the right to health, it does make reference to sexual reproductive health rights. South Africa has the Choice of Termination of Pregnancy Act. That is very liberal compared to the legal framework in Botswana and in Lesotho and in Swaziland and in Zimbabwe. That gives those under 18 the right to terminate a pregnancy beyond the restricted grounds that I discussed with respect to Botswana. The Choice of Termination of Pregnancy Act provides for the legal termination of pregnancy within a reasonable time and for free at public health institutions. In South Africa, fortunately, not only do they have a beautiful constitution that has rights, the courts have been consistent in upholding and protecting and fulfilling those rights. Not only have the courts been vigilant, civil society in South Africa has been particularly vigilant. And this is important when we talk, earlier when I defined sexual reproductive health rights, I gave a very broad definition and indicated that even political dimensions of the impact on social reproductive health rights. And one example in South Africa will illustrate that point. Some time back, South Africa was ruled by President Thabo Mbeki, I think 1998 to 2008. It was a period that was generally regarded in South Africa as the period of HIV/AIDS denialism. President Mbeki rubbished every scientific argument that said HIV causes AIDS. He refuted that. And as a result, the government did not roll out HIV medication to public health institutions. People were dying like flies, and the government was saying there is no link. A civil society organization called TAC, the Treatment Action Campaign Group, took the government to court. It was only then that the government was ordered to roll out ARV, and so many people's lives were saved. So that is in the case of the TAC versus the Minister of Health in South Africa. And although South Africa has this liberal constitutional framework, on the ground, access to these services is also limited. A number of young people in particular still cannot get lawful abortion, notwithstanding what the law says, because again of the attitude of healthcare providers who go behind their back to tell their parents that their children had been to the health center seeking these services and stigmatizing such an attempt. The result is that you'll find that there is a disparity between what the law says and what actually obtains in practice that hinder the enjoyment of these rights. I'm going to give you, just to give you a flavor about the practical difficulties before I conclude. The practical difficulties that women or young girls face in trying to access sexual reproductive health rights in Southern Africa. I'll give you one case in Zimbabwe. The facts of this case were as follows. On the 4th of April 2006, one Mildred Mapungi was attacked and robbed at her home. She immediately upon the robbery reported the matter to the police and informed the police that I require you to take me to the hospital. I need access to emergency contraceptive pill in order to guard against unplanned pregnancy. Later that day, she was taken to the hospital and was attended by a medical practitioner. The medical practitioner said that he could only attend to her request to access emergency contraception pill if the police officer before whom a report was made was present. As a result, she could not be assisted. She went back home and came back the following day. Before she went to the hospital, she went to the police to procure the company of a police officer, because the police officer was required. She returned to the hospital. But the medical practitioner insisted that she also needs a police report, which was not there. And she had been advised on the first appearance that not only do I need the presence of a police officer, the police report was not mentioned, but he said the law requires that I should only provide this pill within 72 hours. So the police report was not there, and the hours were ticking. She appeared later with a police report, and the medical doctor told her, you can guess what she was told?
72 hours.
72 hours have passed. So she was not assisted. She subsequently had no choice. She carried the pregnancy to full term and was later on blessed with a child. But she then brought a suit against the Ministry of Health and Justice for suffering psychological torture, and also claimed maintenance of her child. The issues before the court was whether the agents of the state were negligent in the manner they dealt with her predicament. The court held they were, and directed that she must be compensated. That case illustrates vividly to you the real practical challenges on the ground that women face. In Lesotho, on the 14th of February 2018, the Lesotho High Court delivered a decision, a landmark decision, regarding whether pregnant soldiers could remain in the employ of the military. They were dismissed on the basis that they compromised, by falling pregnant, they compromised military discipline. And the operational readiness of the army. So they were discharged. They sued. The matter came before the courts. And the question before the courts was whether the female soldiers were indeed unfit to perform their duties in the military by virtue simply of being pregnant. The court declared that the decision to dismiss them and the law that underpinned that dismissal, the standing order, violated the equality provisions of the Constitution, and that such decision was unlawful. Justice Sakwani, who delivered the judgment, said that the decision had profound effects on the reproductive rights, freedoms, and careers of female soldiers, including that it operated on the presumption of unfitness to serve even in other non-combative duties, removed the need for an individualized determination, and said that the court noted that the contention by the commander that pregnant soldiers must be discharged because they compromise the army's operational capacity and jeopardize military discipline is a throwback to the patriarchal view that pregnant women are not fit to work and therefore are a disposable workforce. It was a landmark decision. This case is an important milestone for Lesotho because it affirms women's rights to sexual, reproductive, and health rights in the context of employment. The decision will have a positive impact on women in all spheres of employment. The Lesotho High Court has set a precedent that other countries in the region could learn from. I promised Laura that I'll speak for 45 minutes and that when it comes to 1:45, I'll bring down the curtain. I intend to honor that commitment with a last discussion of the last case to give you a practical flavor about these matters that we discuss, to demonstrate to you that they are not theoretical. They are real on the ground, and that we need to do more, all of us, not only the courts, to ensure that these rights are enjoyed. The right to health is fundamental. It defines the very essence of the right to human dignity. It includes the right to the highest attainable standard of health, the right to healthcare services, including reproductive health care. In Kenya, in the case of MA and another, versus the Attorney General and others, women who went on labor were required to pay for lodging at the hospital. Those who couldn't afford to pay, once they were done with delivery, they were detained. They were detained until such time that they were able to pay, and then they could be released. In this case, on the 20th of September 2010, the first petitioner went to a clinic in Nairobi in order to deliver her 5th child. He had chosen this particular hospital because she was told that the cost of delivery amounted to 1,000 shillings. And she had the 1,000 shillings, she knew she'd be able to pay at the end of the delivery. When she got to the hospital, she was told that her baby was in breech position and that delivery was going to be complicated. She was therefore referred to another maternity ward and advised that the fee that will be payable will no longer be 1,000, but to be 3,000 shillings. So she had no choice. As it turned out, there was no complication. Delivery was smooth, went well, but they still demanded that payment, which she couldn't afford. So she was detained. She said during the period of detention that ran for days, she was made to sleep on the floor next to a flooding toilet and contracted pneumonia as a result. She was only rescued by a good Samaritan, the mayor, upon learning of her predicament. So when we talk about these issues, they are not just issues on paper, they are real. In Southern Africa, these are real issues that require attention. But the courts cannot do this on their own. We need everybody on deck, as I said. I need to emphasize, in conclusion, that sexual and reproductive rights are an intrinsic part of the right to health. Recognition of this right in the Constitution and other laws is a good start, but is not sufficient. Fulfillment requires all of us to help. And as I kept on saying, what is contained in the laws is a good start. It's just the promise. The courts must effect that promise. At the end of the day, for these rights to be truly realized, it should not be what the Constitution simply says. Rights, in order to be honored, the spirit of constitutionalism, of the rule of law, of honoring rights, must reside not necessarily in constitutions, but in the hearts and mind of all people of goodwill. If they do, if they reside in the hearts and minds of all people of goodwill, not just in some paper called the Constitution, no right, no Constitution, no law can ever eliminate the existence of those rights if they reside there. I thank you for listening.
You're not allowed to go yet, sorry. We're going to open things up for questions. We've got about 10 minutes left, so I'll just open the floor.
Yes.
Thank you very much for the talk. I wanted to understand, so in the legal framework of Botswana, you mentioned that abortion is legal if a woman's life is in danger. Does the law specify physical danger, or would economic danger, social danger could be arguments?
No. Social and economic danger excluded. It must be physical danger. Yes. Yes.
Thank you very much. I have two different questions. First question is in terms of juxtaposing national law and human rights law, because I was struck with the judgment that was made that used the language of all people rather than privileging citizens.
Yes.
And I 100% support, just to be really clear. But then I was thinking about how under human rights law that a government is allowed to privilege its citizens first,
yes,
and then do for others.
Yes.
And so I wondered in terms of how is it that you were able to use that, the fact that national law in some ways is stronger
yes,
than human rights law in order to be able to.
Yes, very well. Botswana's legal system, the constitution is supreme. It lies at the very top, apex. Constitutional law is part of the Botswana law to the extent that it is not inconsistent with the constitution. So to that extent, the wording of the constitution would be given effect to. If international law or international legal instruments conflict with the constitution, that will be ignored, and the court will give effect to the constitution. Thank you. Yes.
Well, I have a very specific question that's somewhat personally motivated.
Yes.
By the time that I spent in Papua New Guinea.
Yes.
And I know that you are currently working there.
You must be Nancy.
I am.
Good.
Very nice to meet you.
Yes.
I'm an anthropologist who has worked in Papua New Guinea for years, but my question has.
A nice place. Where did you live?
I was down in Dang and on an island off the coast of
Yes.
the mouth of the Secret River.
Yes. Good. Yes.
As well as up in Anga, but that was in
Okay. Okay. Then. Yes.
My question actually has to do with your experience in two places, in South Africa and now in Papua New Guinea, both of which, I mean, the countries that you mentioned, South Africa, Papua New Guinea, are former British / Australian colonies. The legal, what are you finding in the similarities and differences in terms of reproductive health and the status of in particular women health in PNG as opposed to what you just told us in South Africa? Yes. Because my understanding is oftentimes the Papua New Guinea has been influenced by what has been going on in African nations.
Yes. I have been in PNG for a year. I haven't dealt with issues of sexual reproductive human rights. But the foundational basis of the legal system is similar. The English common law is an intrinsic part of the legal system in South Africa, in Botswana, and in PNG. So if you look at the Bill of Rights, it is comparable to the best in the world. It entrenches the right to equality, to equal protection, meaning that there is potential, and I underline the word potential, to protect sexual reproductive health rights, depending on the judge's perspective and application of the Bill of Rights. The little shock that I experienced dealing with a different matter one day, that may, I don't know how it will turn out, but it may be impactful when that time comes to deal with some of these rights, especially because, as you know, religion tends to be used to perpetuate subjugation or oppression of women. And that phrase, of all the constitutions that I have read and thought about. The constitution of PNG declares that PNG is a Christian nation. Not many countries make such declarations. Most countries that subscribe to constitutionalism and the rule of law, they're secular. But the constitution of PNG says that PNG is a Christian nation, which means that whenever such issues are concerned, that may be invoked. To what end, I don't know. Yes?
In this case, is there any Muslim in Papua New Guinea? Is there any Muslim influence when it comes to law in Papua New Guinea?
Is there what?
Any Muslim or Muslim?
Yes, there are other denominations.
Yeah, but you say that they declare it as a Christian.
The constitution says Papua New Guinea is a Christian state.
But do they have Muslims?
Yes.
And how powerful are the Muslims?
I have no idea.
Unfortunately, most of them are modest and are political asylum seekers in Australia. There's not a tradition of there being, as far as I know,
yes.
and local Muslim community.
Yes. Yes.
What's the political party's approach to the post-situation you criticize? Ruling party or opposite party, how their approach about the things you criticize?
Political parties?
Yes. Their approach.
Political parties tend to be their pronouncements on some of the issues around sexual reproductive health rights, on issues of termination of pregnancy, on issues of sexual orientation and preference, is a muted one. They are quiet.
They are very quiet.
They are quiet.
Because,
and they are quiet.
They are conservative Muslim, conservative parties, or put them the
they are quiet
or liberal.
They are quiet because the broader society is conservative and is opposed to those liberal laws. And you find that they say, at least we had a president, Festus Mogae, who of all the presidents we expected to liberalize laws around sexual and reproductive health rights, but he didn't do so. He now chairs an prestigious international group called the Champions for an AIDS-Free Generation. This is an association of former heads of states in Southern Africa. And he's very strong on these rights now. And he was once asked, but we missed a golden opportunity when you're in power. All these things of liberalizing rights around abortion laws, around early marriages, abolishing early marriages, abolishing polygamy, distributing condoms in prisons. You opposed all this. And now you are the champion one. He was very frank. Guess what he said? Can anyone guess? He said, I didn't want to lose an election. He said, I didn't want to lose an election. So that answers you. Yes.
How do people, I mean, this is with respect to Botswana, because how do people react to these changes in the law? Because I'm talking in context of the 2017 judgment on recognition of gender identity in national documentations. So how do people react to these judgments? Because transgenders and same-sex conduct is not that prominent or recognized by people as a right or even as a thing.
The response of the people is a hostile one. They think the courts are out of order, and they think the courts have been are now Western institutions that do not reflect who they are as a people, and so forth. I once appeared before to talk about these issues to a group of traditional leaders and chiefs. They were silent for the whole 1 hour I spoke, and they didn't say anything. At the end, they said, thank you, Judge. I think we should pray for you. Said, I think we should pray for you. So that tells you volumes about their attitude. And the prayer came, and it was to the effect that I must be saved. So people's attitude is one of hostility. They say the courts are lost, they are westernized.
Thank you. Let me build on that. We have 2 minutes left.
Yes.
But I did want to end with kind of a more personal question like that. You really have championed a progressive interpretation of the Constitution in an environment where it's really hard to do that. And so I wonder if you could say something not just about your motivation, but maybe about the challenges or the strategies for really being able to set the types of precedents that you've managed to set in 2 minutes.
It's a good question. I really think that in countries where the Constitution is supreme, and because the Constitution is worded in elastic terms, and because the Constitution is supposed to be a living organism to serve the aspirations and needs, not only of the current generation, but even generations unborn, there is scope to interpret the Constitution in accordance with the contemporary needs and aspirations of society. So I have often leveraged on that in interpreting the Constitution to be forward-looking. I've also leveraged on previous precedent that said Botswana is a member of a civilized community of nations, and its judges should not interpret the law in a manner that is inconsistent with international law unless the Constitution itself prohibits that course. And because the Constitution did not do that, I have often used comparative studies to effect a more transformative jurisprudential agenda. I hope I've answered.
Great. Yes,
Thank you.
Thank you very much. Thank you to Justice Dingake for taking his detour on the way back to PMG, and thank you all for coming and joining us today.
Thank you very much. Thank you for listening.